Item number 1.
Item number 1 is the city attorney report in response to recommendation number 5 of the Neighborhood Council Review Commission's final report regarding procedures to provide neighborhood councils with early notification of matters being considered by city decision makers.
Good morning. Gwen Poindexter, City Attorney. I can give that report for you briefly. We already submitted our written report to you, but basically the council would ask the City Attorney, with the assistance of the CLA, DUN, and the CAO, to jointly report back on a strategy to implement the NCRC recommendation number 5. So basically the report that we submitted reflects that joint strategy. And just a brief background, the NCRC made recommendations in its number 5. Basically, these were suggestions as to how to improve the early notification system for neighbor councils. In the NCRC report, they mentioned that they want to strengthen the ability of the NCs to provide input before decisions are made. And so the NCRC had recommended the adoption of an ordinance to accomplish this, and recommended certain improvements to the system that were outlined in their report. So we analyzed the committee, the CLA, the DUN, the CAO, and the City Attorney, analyzed that NCRC recommendation, read the report that they discussed certain findings, and we came up with this joint strategy, which comprised of basically 3 elements. To do a plan amendment and an ordinance amendment, which would which could comprise that the plan could be amended to amend Article 7, which is the section that codifies the early warning system into the plan, so that it could state that city departments should establish procedures which identify the key decisions that come before their boards or commissions, and then outline how the neighbor councils would get early notification of those key decisions, and then that the plan amendment could also describe the timelines that each department would provide for the early notification. And similarly, the ordinance, which is now codified in the administrative code, could do the same thing, basically to specifically provide that city departments should develop procedures to allow neighborhood councils to provide input before key decisions related to that department are made by the city council, its committees, and commissions. The NCRC recommendation also suggested that neighbor councils should also have early notification of decisions made by departments as contrasted with the city council, the commissions, and the boards. And to do that, to implement that recommendation, the mayor could issue an executive directive which could direct the chief administrative officers of each city department, office, and commission to promulgate these early notification procedures that would allow the NCs to weigh in before departmental decisions are made. The mayor could issue an executive directive to that effect, and then the city council could simply urge the mayor to do so. And finally, we discussed that DUN should issue a survey or develop a survey so that the neighbor councils can identify what are those issues that are important to them, and then survey the department heads to identify what are those key decisions that each department made, so that we can kind of correlate what the departments do and whether that's important to the neighbor councils.
Do we have any testimony on this?
Any
Other than
speaker cards?
There's one speaker card.
City Attorney? Yes, James Hubach.
Thank you very much. I'm a member of the LaSalle Park Neighborhood Council, and we take an interest in a great deal of the ordinances that are being proposed, the taxes that are being proposed, the community design overlays that are being changed, et cetera. And it's very hard to stay up when you've got 12 people trying to figure out what's going on with all the city agencies and representatives. It's hard to come by the information, then we have to digest it, we have to get people together to get a consensus, take it before a board. So I'm very much in support of anything that would help an early notification system to provide more information. However, the recommendation, as I've just heard it and I've read before, to do a survey does not, to me, constitute an early notification system. Why cannot Dunn send out an email to the 80-odd chairs of the neighborhood councils and give them a month so they can meet to make a or to tell Dunn what is important to those neighborhood councils? Why do we have to study, analyze, ponder something as simple as an early notification system? Our council...
Isn't what you just described a survey?
Yeah, but I'm saying, how long is this going to take to study?
Well, I don't think there was any description of the survey.
No, the chances are there'll be a design process and consultations, and yet we're just talking about an early notification system.
Well, Mr. Kim, maybe you could just tell us what, if we were tasked with the responsibility of, and we'll hold your time, but if you were tasked with the responsibility, what kind of survey how would you conduct a survey?
Bungwan Kim, Department of Neighborhood Empowerment. I imagine we would try to follow a parallel process where we identify from the departments what they think are important issues of interest to neighborhood councils, and at the same time use that to go out to neighborhood councils and ask them to prioritize what the issues and concerns are for them.
I see, Mr. Hubach, the problem I'm having with this is, for example, the question about general manager decisions. I mean, general managers are making decisions every single day, and at what point do you define which decisions they should be informing the neighborhood council about, and which they're not interested in? So I really think that when we speak in generic terms, as in the recommendations, we really create an impossibility, because we can't possibly provide all the information that all the departments do. And by the way, the city council doesn't get anything more than neighborhood councils do. Everything that we get, we have to go find. The difference is we have a staff that go. We have one deputy will be assigned to this set of information, and one will be assigned to that, and some might handle 4 or 5 different subjects, and they literally will go to the departments and say what's going on in the 7th Council District, or what's going on in neighborhood councils. So I recognize that the neighborhood council system really isn't suited for that kind of dynamic. I mean, because you don't have a staff, and we certainly can't provide each neighborhood council member with 10, 15 staff members. So so the question is, what would we select? And I think that's the inference I take from the city attorney's recommendation is, before we start saying what should be required information and what shouldn't, we should ask the neighborhood councils what they value the most, and then go to the departments and say, what can you do better in terms of providing information about those particular items? I think some of the priorities are planning, transportation, projects, some public works projects. You just want to know what's going on.
Public safety?
Public safety, I really don't know in terms of early notification. I don't know what it is. Nothing comes to mind. What were you thinking?
Nothing specific, but that a lot of neighborhood councils are involved in public safety issues.
Yeah, but in terms of like the police department, I don't know what kind of notification.
First Amendment
First-
parades and marches. The LEP.
Oh, like if there's a parade, a march, or civil rights demonstration, or something coming down your way, I suppose they could notify you. But
I think you're on the right track in terms of identifying the small number of issues. Yes. In terms of the number of issues that the majority of neighborhood councils are interested in. I think that could be a good starting point.
well, I think Mr. Hubach, I think what you're saying is you want a simple process.
Quick.
And quick. I don't think we need to spend a lot of time on this. How long do you think it would take you to survey neighborhood councils and come back with, say, a list of priorities?
Nothing simple in City Hall.
Don't do it in City Hall, do it someplace else.
Nor with neighborhood councils. Why don't you give us 3 months to try to
3 months?
look at the
Is
survey?
that suitable to you?
It sounds like it's not an early notification process. I'm just saying,
What would you like to see?
I'd like to see Mr. Kim send out an email tomorrow to the chairs of the councils and give them a month to come back with their prioritized list of what's important to them.
And then give the department how long to get it to me?
Another month.
So 2 months.
There you go.
I think we've made progress, so I'm good with that. So why don't, I think, I'm good with that, and assuming Ms. Hahn and Mr. Zine are okay, we'll ask for Dunn to report back after surveying the folks. It doesn't need to be highly technical, because we can figure out some of the top priorities, and in fact, some of those things are already being done by some of the departments. And then come back. I think we should wait to see what the survey produces before we ask the mayor to do an executive directive, or whether we change the ordinance.
Right, that makes sense.
Yeah, I think we should just wait. So that would be my my preference. And as soon as the other members come back, we'll take action on it. If not, it will be a report of 60 days. 60 days, yeah. As the chair, I can't ask you to conduct a survey, I think. Is that okay?
Well, it's better if you have,
It's within his work.
it is. And
So if you took it upon yourself, I'm sure Mr. Zine and
There you
Ms.
go.
Hahn will be here, but if you did it, you would be doing it at the request of the chair, and I'm sure it's within your work.
Well, I think it's something that the neighborhood councils themselves would be interested in as well, so
Yeah.
it's a worthwhile project.
Okay, I'll give you cover if anybody questions you on it.
Thank you.
Okay, so we'll move, did you want to, you have 15 seconds.
Yes, I just want to say, this is an important matter. It is difficult for a neighborhood council, and I've been associated with this one for almost 2 years, and we're just now putting together a ad hoc committee on legislation so that we can, as an organization, try to get more information and reflect back to the city agencies what's.
Yeah, but honestly, my fear, Mr. Hubach, is that if we really wanted to hurt the neighborhood councils, we'd give you all the information.
sure.
So what we really want to do is hone in on the things that you really want, the things that you really need, the things that you can be most productive with. And so you'll help us with that. I'm sure you'll be one of the first participants in the survey.
Certainly.
Okay, good. Thank you. All right, item number 2.
Item number 2 is the city attorney report, resolution, and ordinance relative to the Neighborhood Purposes Grant Program, authorizing the city's neighborhood councils to make monetary awards or grants to nonprofit community organizations and public schools.
Good morning, Peter King with the City Attorney's Office. What you have before you is an ordinance and a plan amendment to authorize the neighborhood councils to make grants to nonprofit organizations and public schools.
That's it? Go ahead.
Currently, the funding that the neighborhood councils receives authorizes them to use the money for their operations and for neighborhood improvement projects. The ordinance does not incorporate all the conditions or all the program itself. The program, it just is the enabling ordinance or the authorization for neighborhood councils to go ahead and make grants to community groups. It's the plan for the citywide system of neighborhood councils where the meat of the program, if you will, is incorporated and referred to. And it's a fairly simple program. Essentially, the neighborhood councils will identify what nonprofit organization or public school they would like to grant money to. They will then take a board action. They will then submit an application that Dunn has crafted to capture all the information about the organization, the legal name of the organization, what the public purpose is for the grant, and will then the department and the department staff will then, with the assistance of the city attorney's office, determine if it is a public purpose. They will then either approve it or not approve it, and it's the same. This is basically modeled after the community services program, where council members,
The general city purposes?
or the general city purposes program, and the only other element to this is that the department, if the grant was over $5,000, would be a more formal grant agreement. Under $5,000, it would not be, I mean, they would capture the information as to who the grantor was, but they wouldn't have a formal agreement. And this is, again, similar to the GCP program, wherein the city has accepted from the city's contracting rules grants made by council members to community groups. Under $5,000, it does not have to be it doesn't have to be a formal agreement. Over $5,000, it does
Describe
have to be.
formal, informal.
Basically,
I mean, you still have to have a description.
You still will have a description. It's just that with a more formal agreement, you will have the specifics as to what the grant money is to be used for.
Is that code for more lawyering?
No, it's actually it's just a public policy decision that when you're talking about greater amounts of money, if the
I'm trying to get the practical.
The practical effect is if they don't follow the agreement, if the grantee does not do with the money what they said they were going to do with the money, then the grantor, that would be the neighborhood council, would have some recourse, something to point to say, wait a minute, you said you were going to use the money for this. Whereas with no formal agreement, with no writing other than, by the way, we gave a grant to this group, then they wouldn't have any ability to point to some language, contract language, that says, wait a minute, we granted you this money for this specific purpose, and you didn't use it for that.
Okay, now, hold on.
Okay.
I don't think I've ever done a GCP allocation without having something in writing.
You do. You do. You run it through the city clerk's office, and they have something in writing. But under the city's contracting rules, and these grants are contracts, they're agreements, because if they're not gifts. A gift of public funds is illegal. But the point is that under the program that you're talking about, GCP, there is a more formal written agreement that takes place when your grant is over $5,000.
That's what I'm trying to. Can you describe what exactly a more formal agreement looks like?
A contract, a 2-page contract, 2 or 3-page contract.
But I'm thinking we get these little. We'll get a letter from a community organization saying they want to do a parade, or they want to do. They want to have a little event, a book signing, a book reading program at the library or something, and they need $250 for refreshments and hot dogs or something. They'll send us a letter making that request. Then we fill out a form to the city clerk.
Mm-hmm.
And
that's it.
And
it's
that's
under
it.
$5,000. If the grants that you're commonly making, are under $5,000, even if it was over $5,000.
But isn't the letter that they send us essentially agreement?
The letter is, but, well, the letter is their intent of what they were going to use the money for. It's more like an MOU. It's a little fuzzier. I mean, you couldn't go into court and say, oh, by the way, we signed this, they signed this. This is what they were supposed to do with the money. They didn't do that with the money. We want our money back. You wouldn't do that because you're not going to sweat the small, under $5,000. And at the time, apparently there was a public policy, because all contracts in the city of Los Angeles over $1,000 have to be in writing and have to be signed off on by the city attorney's office. But for the GCP program, and what we're proposing with this program is, as a matter of policy, we're not going to sweat that there be a formal agreement, or I shouldn't say formal, that there be a written agreement. There doesn't really have to be a written agreement with that group that you talk about, that you were just referring to, that wanted the hot dogs. I mean, if they just picked up the phone and said, gee, we want these hot dogs, and you went over to the city clerk and says, I want to grant money to this group that wants this, there would be no writing at all, except that administratively, the city
I don't-
clerk would know that you've applied for that.
No, I don't think that's how it works. We can never do anything in less than, what is it, 2 weeks? What is it? For GCP, it takes at least 2 weeks for us to get an
Approval.
allocation.
Through the city clerk, is that what you're saying?
No, an allocation, get a check.
Right. Well, candidly, there are certain things that work quite a bit quicker with the neighborhood council system. We put together a leasing program. We've gotten them down to 10 days they can get into an office lease. So that's pretty remarkable considering we had to create a program. And this will be the same thing. This is going to be, the department's going to be overseeing it. The only difficulty you're going to have is there's only 15 council members under the GCP program. You're going to have 88 neighborhood councils that are going to be wanting to make grants. And that's a pretty big workload for the department to administer if they're getting a half a dozen grant requests from 88 neighborhood councils during the course of a year, because each one is going to have to be tracked, and each one is they're going to have to cut a check out of their neighborhood council funds for that. And by the way, all the grants per your request are going to be posted on the website, so it's all going to be transparent, but it'll move as quickly as the department can process them, which hopefully will be as fast, if not faster, than what you're getting to the city clerk's office.
Well, the neighborhood council has to approve these things.
They do. They have to actually take a board motion so that we know it's not just one person on the neighborhood council board that's saying, gee, I think this is a great idea. And also there'll be that element of, are you a board member that's granting money to your own nonprofit?
Well, they should recuse themselves. But,
Right,
But
right.
the point I'm trying to get at is a lot of these requests come in short order, and they're just not going to be able to be responsive because they have to get approval of the board, and then they have to get the allocation. It's going to take at least,
That's
in
true.
best case scenario, a month. Most likely scenario,
That's
2
true.
months.
That's true. Yes,
Yeah,
it will.
Okay. And I think the whole intent here was to not burden, but in any case, Dunn would have to get the request, then they would have to send them to city clerk.
No. Dunn's
No?
going to process.
Oh, you're
these.
going to have
These
the
are
check.
out of the city clerk's
You're going to have the
hands.
checkbook.
Yeah, we'll make the payment directly to the
Okay.
grantee.
Okay. Well, I think the main thing is that we don't want them to wait once they've gone through the process. And if there's a simple document, now the kinds of things that you would be watching out for would be religious proselytizing, conflicts of interest,
501c3 verification.
What if it was a city department like LAPD?
Well, with
Do they
the
not have to go through this process?
No, they wouldn't, because basically and we have encouraged that with the neighborhood councils. Basically, what it is the neighborhood councils are taking the funds that the city public funds and shifting them to another department. For instance, D-Lank.
So in terms of being public funds, you don't worry about that?
We don't, because
And that's
it's
the
all
only
in the
reason
city-
you're
it's all in
worried
our
here?
family.
Is that the only reason you're worried here? Is relative to public funds, or aren't there other
Well, yeah, I
concerns?
mean, one of the concerns is that public funds need to be used for a public purpose.
So that's the primary concern.
That's the primary thing. If it's not going to be used for a public purpose, then we can't approve the grant, because otherwise it would be a gift to public funds.
Mm-hmm.
And what a public purpose is really broad, and it depends on what the legislative body says it is.
Theoretically, could a private organization do something for the public good?
Theoretically, they could.
So
yes.
why are we restricting it?
Where it's, well, I guess what I'm saying is when you open it up, I mean, you know, with a
What about a 501c4,
501c4 is
an educational institution?
It could be, but it could also be a social club. It could also be an unsavory motorcycle club that has a social aspect
Or a
to it.
savory motorcycle.
Or a
club.
savory one,
Remember,
right.
Dennis Zine is a member of this committee.
Well, I'm with him. I'm in Sturgis too. So. But anyway, the point is that this program can be expanded later on to include a broader range of community groups or even private corporations if they were going to be using the money for a public purpose. But generally speaking, government does not give public money to private businesses.
My thing is that it's not the organization that it should be the focus, but what the money is going to be used for. I mean, obviously, if it's the Hells Angels,
Right.
you want to give it more scrutiny. I think I can say that publicly. But if it's a local, let's say the local McDonald's is going to have some kind of event, and we want to expound on it, or you know.
Well, anything's possible. I mean, what we were operating.
You know what happens with our GCP? One organization that it doesn't have their 501c3 goes to the organization that does and says, "Can you put this in for us?" And they put it in, and they co-sponsor it, and it gets done anyeanyway.
Well, I mean, there's other ways to.
But it's the function
Right.
and the purpose that I think is the goal.
Absolutely. I mean, this could be this.
Is a
or
chamber
this
of
program
is a
could be-
chamber of commerce a 501c3 or a 501c4?
The Chamber
It's an
of
advocacy
Commerce
organization,
is-
so I believe it's a 501c4.
It may be a 6. There's about 27 categories of 501c organizations.
But in any case, I don't think it's a 501c3
No, it's not a 501c3.
because they can advocate,
Right.
and
But we-
so
we-
but they do a lot of stuff in the community.
Sure they do, but
That-
their primary mission statement is for the business community. That's why they're not the
No,
50
but they do a lot of public events.
Absolutely.
So why wouldn't the neighborhood council be able to give to their chamber of commerce?
They could if we wanted to draft it that way. But see, the thing is when you draft this ordinance, you either have to include all these categories of, or all these organizations that are approved and would be using the money for a public purpose, and then a lot of organizations that aren't. Or we could just leave it wide open and not, like with the GCP program, and not mention any particular groups. But the concern is that you have some sort of a standard in which the department could approve these.
And just to recall, this was a council direction, so we drafted the ordinance based on the council motion, which was based on Dunn's recommendation, this committee's recommendation, that for the first iteration, the program should be limited to 501c3s and
But see, I
public
think
schools.
the misnomer is that people think that 501c3 capture all these organizations that we give money to.
They don't.
And they don't. And I don't
But-
think that, I'm not sure that was the intent.
Well, originally it was limited to 501c3s because by definition, they operate for charitable purposes,
purpose.
so it was an easy analysis. We were trying to, I think Dunn wanted to at least simplify the program initially and then see how that works. So that was the basis for the council
But I think
direction.
there's a pragmatic reality out there. What is most likely to be a recipient of grants, and the Chamber of Commerce is right up there in the top 5, if not higher. I mean, I can't think of an organization that you know,
Well, as I said,
that
that's
is more
true.
engaged in public stuff
Right.
and public purpose kinds of activities than the chamber in most communities. Are you aware of? Don't the neighborhood councils have great relationships with the chambers of commerce, or?
It varies widely.
But they are engaged. I mean,
In some neighborhood councils, they are.
well, so then the chamber would have to go through some nonprofit to get.
Right.
But as my colleague Gwen pointed out, this is what the way we
And then
were
if the
directed.
nonprofit gets the check and then spends it for some other purpose, what could the chamber do?
Yeah.
And what could Dunn do?
Right.
I think that was our perspective, is that establish a 1-year trial period and see what the demand is like, and then we'll come back to the committee, see if there's a need for expanding the program. But Dunn is way behind on our funding program, so workload is definitely an issue right now.
You have a bunch of money?
No, we have a bunch of audits that we have a backlog on.
Audits of?
Audits of neighborhood councils, funding program.
But you want to rush this through?
No, we are in no particular hurry to rush this. That's why we are urging that we simplify it on the front end.
Well, I'll send it. Only because I think this is it's a lot to do about little. I really think the neighborhood councils will be frugal with their small amount of money, and I think they'll probably be very responsible, and that the administrative requirements that we set should be as simple as possible.
I would agree with that.
If you want to broaden this, we certainly can. We'll write it any way you want it. It's just that this was the direction we were given, and so that's the way we went with the drafting of the ordinance and the plan. But if you want to broaden it to just community organizations, you could do that. The main thing is we're looking at that public purpose. Is it for a public purpose?
Mm-hmm. Well, if this was the specific direction of the council,
Yes, it was.
then I think let's go with that. And if there's a hue and cry from the neighborhood council system, if they're not getting the message right now, then they can ask for other organizations to be included. So, for example, Neighborhood Watch or is Neighborhood Watch, what would that, is that a nonprofit corporation? What is that?
Neighborhood Watch isn't a nonprofit organization.
Or the DARE program. It's not a specific entity, but it is a 501c3. Probably.
Homeowners associations could be a 501c6 or 4. I mean, there's just so many.
Well, let's see what kind of requests come in, but what you have to be cognizant of, Mr. Kim, is that whoever's getting those forms in and allocating that money needs to know the difference between a 501c3 and everything else out there.
Right, and that's the administrative screen that we'll set up.
Okay. And I know you're well aware of that, but...
Yes, I am.
Okay, thank you, and that would be the order. If we get another council member, we'll take a vote. If we don't, then we'll just send it. We'll just send it to council directly.
Okay, you can go forward as a communication from the
That's
chair.
fine. That's fine. Item number 3.
Item number 3 is the city attorney report, supplemental report, an ordinance in response to motion Perry Parks relative to amending language to clarify the city's current truancy regulations.
Good morning, Deputy City Attorney Julie Raffish.
Hi.
Hi.
Good morning. Fabian Lizaraga, Commanding Officer of Juvenile Division.
How you doing? Go ahead.
The last time this matter was before this committee, we had a discussion about proposed amendments to the daytime juvenile curfew ordinance and a discussion concerning the applicability of other municipalities' ordinances and some questions posed by yourself and some of the other council members present. I have prepared and submitted a supplemental report to the committee, hopefully providing a little bit more information concerning how courts look at these types of ordinances and certainly the wide discretion that the council has in terms of making any amendments to the existing ordinance, which I believe has been on the books since 1995. And I'm happy to answer any questions you have.
So the specific recommendation before us is to change the ordinance to do what?
The specific recommendation is to adopt the proposed amendments. There were amendments made to both the daytime curfew ordinance as well as the nighttime ordinance, although the daytime curfew ordinance was certainly the greater focus and the impetus for the
Then let's
amendments.
start with the nighttime ordinance. What changes are we recommending?
In the nighttime ordinance, we simply made some technical changes to some of the verbiage to tighten it up.
What does that mean?
What it means is that we took out some of the legalese that existed in the original ordinance. If you'll give me a moment, I'll pull my original ordinance out and I can be specific. my file has grown quite thick over the last couple of years with respect to this, so. Okay. In the nighttime ordinance, we changed some of the language. In the old ordinance, it indicates in the introductory paragraph that it's unlawful for any minor under the age of 18 to be present in or upon certain locations, public locations. And then it says, provided, however, that the provisions of this section shall not apply. And we simply kind of reorganized the ordinance in a way that made more sense. So you have the general curfew.
Can you tell me the practical impact of the language changes? Is there any?
On the nighttime ordinance,
Yeah.
not very much. What we did do, and which is significant to this committee, is that we added a First Amendment exception to the nighttime ordinance.
Okay, so that's the singular
That's the most significant change.
The nighttime ordinance. And that means basically that if they're going to a meeting at the school to express their opinion about an item that the school board is considering, that they would not be subject to the nighttime curfew rules.
That's correct. If they were exercising their rights under the
Okay.
First Amendment to the Constitution, which isn't just freedom of speech, but it's
Mhm.
freedom of religion and freedom of association.
Okay. So the daytime ordinance is much more complicated because of the authority of the schools.
Correct.
And I don't believe anything we do supersedes their authority. But my main question is, does it not put us in a greater position of liability if we fail to act? That's my concern. Basically what I'm saying is, if a kid is supposed to be in school, they don't get permission from the school, but they go to a protest.
Mm-hmm.
The kid then gets injured and then sues the city, or a police officer engages, realizes, or just observes that they're at a protest. And so they don't take action because they're observing that they're expressing their civil rights, but they have no permission from the school to participate in the protest. It's my understanding that the schools have authority to limit the civil rights of students different than other jurisdictions. And if we fail to recognize that, and then the student is injured in a protest, wouldn't the city be liable for failing to act on state law?
Well, your question raises a lot of different nuances and a lot of different issues, so hopefully I'll be able to address them all. The first thing is, with respect to law enforcement in general, officers do not have an affirmative duty to take police action. They do not have an affirmative duty to make arrests or to issue citations. The duty and the breach of that duty, which gives rise to liability, occurs when a special relationship is established between the law enforcement agency and the person in the community, the person who's affected.
So the fact that the police are guiding the protesters on the street is not engaging significantly enough?
No. And I would also suggest that, and I think I've spoken with a member of your staff about this as well, that the police department, I believe, is interested in taking enforcement action when a violation of the ordinance is present. If there have been occasions during the last 2 years where enforcement action was not taken under the circumstances that you've described, that's because, in light of the need to create amendments to the ordinance and to make the ordinance more defensible, to withstand a challenge if one was brought in court, the police department has been advised to refrain from enforcing until an ordinance that was solid in nature and could withstand challenge was actually enacted, so that there would be no question regarding the validity or the lawfulness of the issuance of those citations. The draft ordinance that you have before you does not explicitly contain a First Amendment exception for the daytime curfew. However, it contains the first provision, as I pointed out in my supplemental report, which allows the minor to engage in unlimited activity, including First Amendment
So
activity.
if a kid decides they're going to join the Hemp Club of America, and they have what would otherwise be described as a ditch party to express their civil rights about legalization of marijuana.
Mhm.
Under this ordinance that is being recommended, would the police be able to enforce action?
They would be able to take enforcement action if it was determined that the individual was not accompanied by his or her parent, guardian, or other person over the age of 18 who has been authorized by the parent or guardian to have care and custody over that minor during that time.
Okay. So the parent, so this is a limited exemption for their civil rights.
It is.
But they can express their civil rights, but only if their parents allow them to.
Correct. Or if it's really a matter of supervision, because it doesn't necessarily have to be it has to be either the parent or the guardian or another adult who has been authorized. And that adult person can be a school administrator, a teacher, or somebody over the age of 18 who's been authorized by the parent or guardian, so that the parent or guardian, the same parent or guardian who's dropped that minor off at school that day, assuming they're going to be in the custody and the care.
It has to be somebody that the parent
has designated or approved.
Or has authority under some official capacity.
That's correct.
That sounds a lot better. Does the police department tell us how you feel about this ordinance change, the proposed change?
From our perspective, council member, the the issue that you just spoke of, if young people are going to leave school, obviously the police department would prefer that school administrators or teachers are with them. It's an organized, structured event for public safety reasons, that we just don't have 100 kids that decide to walk up the off-ramp of the Harbor Freeway and put themselves in danger because they're not thinking clearly, because they don't have adult supervision. Right. It is at that time that we would act and take enforcement action. So the preference and the ordinance provides for that would be that the parents are involved, or some of the parents have authorized, in this case school administrators or teachers, and that's a structured, organized event in furtherance of their First Amendment rights. So we're looking at it more from a public safety perspective, and for the safety of the students and for the safety of the public.
Well, when the massive school walkouts occurred a couple of years ago, if I recall, the LAPD took a very passive approach to that.
And we did, and we have to take a measured response.
Were there any arrests? Were there a few, perhaps?
There was a few arrests. I remember I was in Van Nuys at the time, and in the Valley we had maybe 2 or 3 that I remember were arrested, but that was for not for the any truancy or curfew violations. It was for instigating a fight amongst the protesters and stuff. But for the most part, we monitored. We made sure that vehicle traffic didn't bump up against pedestrian traffic, and try to keep everybody on sidewalks as much as we could, and it spilled over to the street. But even then, it was still manageable, and so we took that stance in that position.
Okay, so is LAPD comfortable with the language proposed in the ordinance changes?
We are, sir.
Yes.
Okay, and supportive of it?
And supportive
Yes.
of it.
Do you believe it'll allow you to increase the public safety?
We believe that it's a functional ordinance that will allow us to do the things we need to do to provide for the safety of all concerned. Absolutely.
That sounds good to me. Is there any other testimony on this? My hesitation is that on the one hand, I have many different hats I'm wearing right now, not just as city council member, but as a former teacher and obviously as a parent. And yet I'm also, when I was in high school, very involved in civil disobedience activities, particularly protesting the war in Vietnam. And so at the same time, we don't want people to get hurt. And I'm also concerned about we had a unique situation when 50,000 kids walk out of school. The school district really loses control. I mean, they have they should be monitoring our kids. They should be the primary authority responsible for these kids. But when they walk out their gates, they lose complete control. And it puts the LAPD in particular in a very awkward situation, even less so than the school district police, who are getting specific directives from the school district. And there's just all kinds of complications. But if I'm hearing that the department is supportive of this ordinance, and the city attorney feels that that we won't be creating liability situations, although anybody could sue.
I was going to say, I think it would be difficult for me to say that this ordinance will prevent anyone from bringing a lawsuit on any ground.
Well, they sued us before for the way it was before.
They
sue us the way it is now.
Right. I mean, there's always somebody who feels that there needs to be a challenge, but I think that what we've tried to do is tighten up the ordinance in a way that really does reflect the city council's need and desire to protect a vulnerable population of the community, as well as preserving some of the rights that same population has to move and to be heard. So we're really trying to create an ordinance that strikes a balance, and we hope that we've done that in this case.
Councilmember, can I offer also
let me ask it.
Sure.
I just had a thought. What if it was a teacher who encouraged their kids to get involved in political activity, and they go out there and get involved? Is that an implied authority? Or?
That adult would have to, when asked by a law enforcement officer, accept full responsibility for the care and custody of those minors that are out. I mean, they couldn't.
What if they're not present?
Well, that would be problematic. That would be
But
problematic.
they would have to be present. So if a kid is walking precincts on a campaign and they get stopped. I remember when I ran for office the first time for city council, on the day of the election, my partner in walking the precinct was a 15-year-old student. And there was no school that day. And, but there was no teacher present. There was no letter from the parent.
Those determinations are made when the officer encounters someone who is under the age of 18.
I doubt that LAPD would have stopped me and said, no, you can't do this.
The issue for us is obviously the letter and the spirit of the law,
Yeah.
and to take many things into account, to do some due diligence to find out what the person's doing, what their purpose is, those kinds of things. Back to the original walkout, oftentimes in those situations, if we have a large number of young people, we may choose not to take enforcement action. We may go into a public safety mode and actually provide for their safe movement.
Exactly.
Because that's the reasonable thing to do at that moment in time. So, again, we're going to have to adapt and adjust based on the circumstances and do what we believe to be right. As Julie mentioned, there's no affirmative responsibility. We don't have to corral 1,000 young people and issue 1,000 citations. The idea is to provide for their public safety.
It sounds like all the messages have been covered in a positive way. We're trying to protect their civil rights. We're trying to, in fact, many of the protest activities are more educational than the classwork they're doing in school. I think, given the city attorney's opinion, the LAPD's representation, and the reality of what happened a couple of years ago, I think we're moving in the right direction. And so I think I have no problem sending this forward. And if something comes back, however, please let us know as quickly as possible so that we don't create more dilemmas, and particularly liability. So with that, I'll be happy to send the report forward to council. And there's no other public comment?
There are none.
With no public comment, this meeting's adjourned.
Thank you
very
very
much.
Thank you.